Welcome to California Bar Prep, your study companion for the California Bar exam. In this lesson, Erie Doctrine and choice of law in federal court. Let's begin. Erie is tested because federal courts hearing state law claims must be federal courts without becoming a separate source of general common law. The exam usually gives a diversity case, a federal rule or federal practice, and a competing state rule that would change the result. Your job is to identify the source of the federal rule, then choose the correct analysis. Do not begin with the twin aims unless there is no valid federal rule, statute, or constitutional provision on point. Erie is a hierarchy problem. Core rule, a federal court sitting in diversity, or deciding state law claims through supplemental jurisdiction, applies federal procedural law and the substantive law of the state in which it sits, including that state's choice of law rules. Vertical choice of law. The federal court applies the forum state's substantive law because there is no general federal common law. Horizontal choice of law. The federal court applies the forum state's choice of law rules, even if those rules select another state's substantive law. Federal question anchor. Erie still governs state law claims joined with federal claims. A federal court does not create a special federal common law merely because the case also includes a federal cause of action. Step 1. Identify the claim. If the claim arises under federal law, federal substantive law governs that claim. If the claim arises under state law, Erie governs that claim. Supplemental jurisdiction changes the jurisdictional basis, not the governing substantive law. Step 2. Ask whether a federal directive is on point. The Constitution controls if valid. A federal statute controls if valid under constitutional authority. A federal rule of civil procedure controls if it is on point and valid under the Rules Enabling Act. Step 3. If a federal rule is on point, use Hannah. The rule applies if it arguably regulates procedure and does not abridge, enlarge, or modify substantive rights. Federal rules are almost always valid on the MBE. Do not reject a federal rule merely because applying it affects the outcome. Step 4. If no federal directive is on point, use the Erie-Yorkburg-Hannah analysis. Is the state rule bound up with substantive rights and obligations? Would ignoring it be outcome-determinative in the sense of encouraging forum shopping or inequitable administration of the laws? Is there a countervailing federal interest in the federal practice? Choice of law. Once state law applies, use the choice of law rules of the state where the federal court sits, not the law of the state with the most attractive policy, and not federal choice of law rules. Substantive rules generally include elements of claims and defenses, statutes of limitations for state claims, tolling rules closely tied to limitations, burdens of proof on state law claims or defenses, standards for new trial or excessiveness of verdict when state law defines the right, claim preclusion and issue preclusion effect of state judgments. State rules allocating primary conduct, such as negligence standards or damages caps when substantive. Procedural rules generally include pleading standards under the federal rules, discovery rules, form and timing of federal motions, jury selection mechanics, summary judgment procedure, judge-jury allocation when governed by the Seventh Amendment or federal practice. Service rules if a federal rule directly addresses the issue. California law may be the substantive law selected in a federal diversity case filed in California, but the federal court still uses federal procedure. California pleading labels, demur practice, anti-SLAPP nuances, or state court motion terminology do not automatically displace the federal rules. California choice of law. California generally uses a governmental interest approach. In a diversity case filed in the Central District of California, the federal court uses California's choice of law method to decide whether California law or another state's law governs a state law claim. California limitations and tolling. If a California statute of limitations applies to a state law claim, a federal diversity court ordinarily treats it as substantive. Federal filing rules may govern when a federal action is commenced, but state limitations policy can still determine whether the claim is timely. Note: California's broad discovery and state motion practice do not control in federal court when the federal rules directly cover the matter. Trap 1. Starting with outcome determinative too early. If there is a federal rule on point, analyze validity under the Rules Enabling Act first. Only when no federal directive controls do you use the twin aims and federal interest balancing. Trap 2. Assuming federal court means federal common law. Federal courts do not make general common law for state tort, contract, property, or limitations questions. Trap 3. Confusing venue transfer with Erie. After a transfer for convenience, the transferee federal court generally applies the state law and choice of law rules that the transfer court would have applied, so a party cannot use transfer to obtain better substantive law. After a transfer for improper venue, the transferee applies its own forum state's choice of law rules. Trap 4. Treating every outcome effect as substantive. Most procedural rules affect outcomes. Erie asks whether ignoring state law would substantially encourage forum shopping or inequitable administration, unless a valid federal rule controls. Trap 5. Forgetting federal constitutional constraints. The 7th Amendment governs the right to jury trial in federal court even for state law claims. State judge-jury allocation may matter, but a strong federal constitutional policy can control. Trap 6. Misusing state choice of law rules. The relevant choice of law rules are those of the forum state where the federal court sits, not necessarily the state whose law the judge personally believes is most connected. A classic question says, in state court, a plaintiff must file a certificate, post a bond, use a special pleading, or satisfy a state service rule. In federal diversity court, the plaintiff complied with the federal rules, but not the state rule. First ask whether a federal rule directly answers. If yes, the federal rule almost always wins. If not, ask whether the state requirement is substantive enough that failing to apply it would encourage forum shopping or inequitable administration. Another common pattern involves statutes of limitations. The answer is usually that the federal diversity court applies the forum state's limitation period and integrated tolling law for state law claims. But the manner of filing, amendment, relation back, or pleading may be governed by a federal rule if directly on point. A third pattern involves choice of law. A diversity action is filed in federal court in California after an accident in Nevada between parties from different states. The court does not create a federal conflicts rule. It uses California's choice of law rules. Those rules may then select Nevada's substantive law. A tax sequence. State the Erie baseline. Federal procedure. State substantive law. Identify any federal rule, statute, or constitutional provision on point. If present, apply it if valid. If absent, evaluate substance, twin aims, and federal interests. For state law content, apply the forum state's choice of law rules. Exam payoff. The correct answer often turns on source. Federal rule on point equals federal rule. No federal rule. State rule affects primary rights or forum shopping equals state rule. Choice of law question equals forum state's choice of law rules. That's it for this lesson. Download California Bar Prep on the App Store for lessons on all 14 bar subjects, practice questions, and essay frameworks. Keep studying, and good luck on the bar exam.